Frank Dermott from Irish Temple Chambers, naturally.
Yeah.
And I'm very pleased to welcome all of you to this travel conference, which is becoming really quite the annual event for us in Manchester. I suppose I've done cross-border work for maybe 30 years. It wasn't called travel law then. I'm not sure what it was called. I used to call it cross-border personal injury and cross-border clinical negligence. And then maybe 15 years ago, I met Sarah Crowther, who's quite well known in the field. She was then at Hair Court, and I was talking to her. And in fact, I was giving a seminar in Berlin. You said Berlin, on cross-border clinical negligence. And she came up to me afterwards and said, "We do a bit of that in our chambers." So I started talking to her. I said, "We do a bit of it. It looks to me like you're sort of fairly much leaders in it." Anyway, she joined us. I'm very pleased that the team has grown since then, with Ian Denham and all the other juniors that have taken so well to this area of work and built our reputation. Without further ado, I've got lots more stories, but you don't want to hear those. Perhaps we'll drink later. We're going to change the order a little bit. Sarah Crowther is so urgent now that she's got to finish a conference before she can get here. And so we're going to hear first from Jatinder Paul and Will Young. Jatinder Paul is probably well known to all of you. He's a partner in the International Serious Injury Team for Irwin Mitchell. He's a trustee of GAIN, which is a charity supporting people with neuropathic conditions, and a fellow of ATL. And actually probably most famous in the law at the moment for being involved in Chewy and Griffiths, I think for the appellant, is that right? Correct. But also involved in a lot of group actions. And actually becoming quite a senior statesman in travel law now. And then he's going to talk to Will Young. Will Young is probably well known to quite a number of you. Super junior in Outer Temple Chambers. He does a lot of travel law, does a lot of group actions, does a lot of top flight personal injury. And it looks as though he was also junior counsel in a disability discrimination case in which the claimant was awarded the highest award ever made in a discrimination case of 4.7 million. I happen to know that because I let it. Pretty brilliant. And so we start, what a great panel to start with. Without more ado, I'm going to sit down and get out of the way.
Thank you very much, Gerald, and thank you very much to everyone for joining us. Perhaps appropriate on the morning of the first Lord's Test of the cricket summer, that Jatinder and I have been promoted up the batting order to open the batting, and we'll try and get some early runs on the board. We are going to talk first we are talking about group actions, group claims, and the format for today, for the first talk, is going to be hopefully fairly informal and conversational. We are going to talk about various aspects of group claims and the types of issues that come up and are perhaps of interest. Just by way of very brief introduction, my experience in group claims is a mixture of travel, particularly package travel group claims, many of which I did with Jatinder in the early days of my practice, and then also more recently some more clinical negligence type group claims, including some hip replacement clinical negligence group claims, and also I am junior counsel for one of the claimant groups in the Lariam MOD claims. So, Jatinder, before we start, do you want to just say a little bit about your group claim experience and what your perspective on it is?
Yes, absolutely. Thanks, Will, and thanks, Gerard. So, predominantly, my practice relates to mass illness outbreaks abroad, usually on holidaymakers on spoilt package holidays, but also a growing area of our practice at Irwin Mitchell are outbreaks relating to environmental contamination. So, Ian Denham and I are working on you've probably heard this from Ian's talk last week to Piopal, but we're working on a large, widespread contamination issue at the Royal Papworth Hospital, by way of example, and that's in Oxfordshire. So my experience is predominantly group actions, and a lot of what we're talking today may be quite obvious to those that work in group actions, but it's an area of law that is constantly changing, constantly moving forward. I'll try not I'll try my best not to talk too much about Griffiths today, because I don't want to tempt fate, as we've got a hearing this month now, as it's the 1st of June, which we're all quite nervous about. So without further ado, Will, we can
Sure.
move
So
forward.
I think we're going to start by just talking a little bit about or introducing rather the difference between group claims and class actions and the kinds of group claims that you can have. There is obviously under CPR 19.6 the possibility for bringing representative claims. There's also in competition law you can have class actions, but generally within the personal injury sphere, what we're talking about is either representative claims or group claims. We're actually not going to talk very much about the 19.6 representative claims very much, because they tend to be less common. The CPR and the guidance from it in the white book has some very helpful guidance about the scope of the CPR 19.6 provisions, but they are more niche than what we are talking about, because in order to qualify for that type of claim, the claimants all have to have the same interest, and hence they are rather less common in the sphere that we are talking about. What tends to be more common is group claims, either by way of a formal group litigation order or simply informally, whereby group of claims based on the same or related subject matter are managed together, either by way of lead claimants or as a group. And I've said there that there are various types of group claims. Data breach claims, so that was the subject of the Supreme Court case involving Google that led to the most recent guidance on representative claimants. But I think what we are talking about more commonly tends to be either group illness claims or contamination claims of the type that Jatinder has mentioned just now, or in the clinical negligence sphere, it is often medication and things like that is the subject matter.
The only other thing that I wanted to say, I think you've just summarised that really well, Will, but the other thing that I want to say, the distinction between a group action and a class action. So class actions actually, until very recently, due to the advent of CPR 19.6, is not very common in England and Wales. And actually, with the representative actions that have started with, for example, the Google data breach from a couple of years ago, they're actually very difficult to start off. Group actions are quite straightforward. You do need to, try to resist attempts by defendants, if you're a claimant, from splitting them apart. But essentially, if you can group cases together on one claim form, then it's classed as a group action. So as far as we're concerned, Irwin Mitchell, for example, anything more than one client is a group of claimants.
And that would include claims of the kind that we used to do when I was very junior, where it would be just a family on holiday and exposure to pathogen causing illness, and technically that's a group claim, even if there are only sort of 3 or 4 claimants. We've already touched on this, product liability, that can be pure product liability, i.e. where you are suing the manufacturer or producer of the particular product. Often they are medical devices or medication, or they can be clinical negligence. So by way of example, the Lariam claims, the defendants in that are the MOD, because they were prescribed to serving soldiers rather than the manufacturer. So it's not that claim is not actually a pure product liability claim. It's a clinical negligence claim, but involving medications. We've touched on illness outbreaks, and I think that coach classes is another example of the kind of claim that you've done a lot of, Jatinder. That's right, isn't it?
Yeah, absolutely. So in terms of illness outbreaks, that's anything, as far as we're concerned, is classed as a group illness outbreak. We summarise that as anything more than 10 clients. But as I say, actually anything more than one claimant is, strictly speaking, should be classed as a group. We've also at Irwin Mitchell had lots of experience of dealing with coach crashes, which bring with them, especially when they're abroad, lots of different challenges of handling group litigation, such as cross-border forum complications, which usually involves us working with co-counsel from different jurisdictions. But again, these are all quite common group action type cases. But as I said, if there's other areas of growing interest in this type of sphere, and we've seen, as I say, lots of interest in environmental cases, and that's another growing area that we're interested in.
And presumably there is a distinction that can be drawn between particularly coach crashes and illness outbreaks, in the sense that obviously one of the things that you have to prove in an illness outbreak case or a food contamination case is that there was a contamination that caused the illness. So it makes the claim inherently stronger if you've got a large group, or at least more than one claimant, because it's inherently more likely that their illness is caused by contamination, whereas in a coach crash, it either happened or it didn't. So,
well, absolutely, that's something I was going to touch upon moving forward. But what we find that group actions, the larger the group, the better the case is on liability, because it is as basic as this sounds, but it is strength in numbers. So if there's one or two clients, their case may, and there's a hotel, for example, that has an occupancy of around 1,000 holidaymakers at any given time, it can sometimes be quite difficult on liability. But if you've got larger groups of people that have been impacted and they've all got quite similar complaints in respect of breach of duty, that case, as far as we're concerned, is a lot easier to pursue, and it we've seen that those cases generally will settle quite quickly on in the proceedings.
Although, of course, and we'll come to this in a minute, there are downsides to having large groups, and we'll come to that in a minute. So we wanted to start by talking about the beginnings of a group claim, and I'll hand over to you, Jatinder, if I may, because you've got more hands-on experience of how that works.
Yeah, absolutely. Before we instruct counsel, there's quite a bit of work, as you can probably imagine, that needs to go into establishing and growing a group action. We normally will be approached by, say, one or two families who have, and I'll give an example. Last August, we were approached by a couple of families who had experienced quite significant illness at a couple of hotels in the Cape Verde. You may have also seen in the press that this has now turned into a quite large group action of several hundred holidaymakers that have suffered quite debilitating and severe illnesses at these particular hotels in the Cape Verde. But they didn't all come to us, as you can imagine. They didn't come through the door all together. And what we do is, as it says on the slide, we will take instructions from an early claimant, and what I mean by that is the first one that comes to us, and then we will use that client, if they agree, obviously, as a client ambassador. So what we find in trying to grow a group action is press is key. We will always issue a press release with client consent, and that will drive further holidaymakers into the group action.
Can I just ask there, do they, when those early claimants come to you, do they tend to say, we were ill and we know that other people were ill, or is that an inference you have to make yourself?
No, absolutely not. So it's offered to us, and so what we found more common, and I was just talking about this in the office actually, is holidaymakers and claimants are quite savvy these days. So what we found is, where people used to walk around in the early days with clipboards, we've obviously got things like WhatsApp now. So all of these clients, sometimes through Facebook, sometimes through WhatsApp, will join that, and that's a point, an avenue for us to explore other people that have had the same complaints. But I would say WhatsApp and Facebook has a warning sign as well, in the sense that it can also cause issues further down the line. Something we're experiencing at the moment, when we're taking instructions from one family, they'll put that into the WhatsApp group, and then all of the clients are saying, but you told us this and you told us that. So there's swings and roundabouts with WhatsApp, but we found, in terms of growing and starting a group action, it's been hugely helpful. The other thing that I just wanted to talk about was, there's also importance around co-counsel agreements and arrangements. So we often, not on illness outbreak cases, but on other types of, for example, aviation incidents, we work with lawyers across the world. So Italy, America, other jurisdictions, to pool our resources, but also to pool our technical expertise. So another avenue for growing groups is talking to, and this is why these types of events are so important. So talking to other lawyers across the world to look at whether we can gather and pool our clients together and pursue a group action against a common defendant together. So that's another area and another avenue to grow a group.
So linked to the starting process of the claim is obviously vetting of claims and vetting of claimants. You've already touched on the fact that the size of the claimant cohort can be important in terms of settlement, both because in claims where the size of the outbreak of a number of claimants has a direct effect on how likely it is that they can prove liability, but also even in cases where that's less the case, it does have an effect on the dynamics of interaction between the parties and pressures for settlement and things like that. But I mentioned earlier that there is a flip side to that, which is that perhaps in cases where the number of the claimants is not inherently strengthening to the claim, then potentially, well, do you think it's fair to say that there can be downsides in that the size of the claimant cohort can become unmanageable if you've got a really big claimant cohort? It's harder to get a handle on the individual prospects of the individual cases, the details, all that sort of stuff, and managing medical evidence for individual claimants, or do you think that's not right?
I think you make a good point, Will, but I think resourcing of these large scale group actions is quite important, but I don't think it makes an impact on how the case is handled, but more so in the world of, in the era of things like fundamental dishonesty, claimants jumping on the bandwagon.
Yeah,
this is all, and those claimants, when they're either incredible or dishonest, it can contaminate your group action, can cause a bit of a distraction for the rest of the case. So I think you make a really valid point. I don't think it impacts on how the case moves forward, but the vetting of claims is key. As far as I'm concerned, it's probably the most important stage in any group action. So vetting of claims is important for those reasons. And what I mean by vetting is quite important as well. So from my experience, vetting is doing social media checks very early on. Don't just take the claimant's word for it. What we do actually is sometimes ask for usernames and passwords for social media to do our own checks. We don't wait till it's raised by the defendant. So we're proactive in that respect. So social media, and what I mean by social media, I don't just mean things like Facebook, Twitter, Instagram, which are important, but the other, especially when claimants are on package holidays, but things like TripAdvisor, from the case that I mentioned from this year, the Cape Verde cases, we found, for example, TripAdvisor and other forums really useful from not only a liability perspective, but weeding out cases that we probably shouldn't accept. But checking bank and credit card statements is also quite important, especially when someone's on, for example, a package holiday and a bank statement shows that they were actually eating out in a restaurant, whereas you've said that they've not been anywhere outside the hotel. So that's obviously also quite important. Photographs, videos, I guess everybody knows how important those are with the advent of fundamental dishonesty. Again, my advice is to be proactive and check that before it's raised by a defendant.
Where do you draw the line, or rather, what's the process for drawing the line for merits assessments when you are doing this vetting process? Because I can see that on the one hand, you might think if we've got a big claimant group of a couple of hundred people, then maybe some cases which, if they were part of a 2 or 3 claimant group, you might have some real concerns about the liability because there are risks, whether it's social media or whatever it may be. You might think that some less strong cases would get lost in the size of the cohort. But I suppose on the other hand, your point about contamination, if you have some in there that are less strong and the defendant picks up that they're less strong, then that might have an effect at bleeding into even the stronger claims.
Absolutely. I think what we do is we have pre-screening questions. So for example, if somebody's not even reported their illness to, say, their GP or the tour representative, I'm using the illness case as a case study, but if we have, before we even speak to a client, when they come through the doors, if they've not reported their illness to either a tour representative or been to their GP, then that's a complete
Yeah.
turn away. So we won't even take the case any further forward. It is onerous. You make a valid point, especially as the numbers get larger and larger. It is onerous, but it's very important. And as far as I'm concerned, it's something that we need to get right quite early on, because once you start investing in these cases, they can get out of control in terms of costs, especially if you're distracted and putting your money and your resource into cases that will essentially be weeded out later on. So my strong view is, yes, it is onerous, but you need to do it quite early on.
And I think related to that is, so you had the initial vetting, whether people are going to become part of the group claim at all, but you then got the selection of lead cases, which is related to the vetting process, because presumably the vetting you've done at the outset will help you in deciding on who the lead cases are. And the two questions I put on the slide are whether, so I think two of the most obvious questions about selection of lead cases is whether the claimants themselves should select the lead cases, or whether that should be a joint process whereby, say, the claimant will select 2 or 3 and the defendant will select 2 or 3 as well. And related to that is, what should the criteria be for selecting lead cases? Should it be that the claimants want to put forward their strongest cases, or should it be a representative sample that include the kinds of issues that will come up more widely within the cohort? And I'm very interested to hear what you think, but I'll give you my very brief tuppence worth to start with. Again, it's two sides of a coin thing, I think, because particularly where you think the key battle is going to be the generic issue, if liability is strongly contested, as a claimant, you don't really want any lead cases that are going to weaken your case on the generic issue. And if the battle of the first battle that you have to win, or you're not going to get anywhere, is winning on the generic issue on liability, then it seems to me that you want to put forward your strongest cases. And then if you have other cases in the cohort that are less strong, you can deal with them later. Although I do acknowledge that the counter argument to that is that there's not that much point in showing that you can win with just your strongest 2 or 3 cases if all of the other ones have problems. And hence, although you may get over the hurdle of the generic issue, you've got to fight the battle all over again with all the other cases, because there are, whether it be limitation issues or they've got their own individual problems. What are your thoughts on those two questions?
Good question, Will. I mean, it goes without saying, it would be lovely if we could just pick all of the claimant's strongest cases, but we know that that's an argument that's going to usually cause satellite litigation for weeks, if not months. And it would literally, as far as from my experience, it will slow down the case, it would delay matters, and it's delaying essentially justice for the claimants in the group action who are the stronger cases. So my view, and it's always been my view, is to pick a representative sample. And you might be wondering what you mean by that. And what I mean is, for example, so if we have a group of, say, 100, we'll pick 10 lead cases. And what we normally do to encourage an agreement between the parties is allow and put this into the directions as well, and with a deadline, is for the claimant to suggest 5 lead cases and for the defendant to suggest 5 lead cases. Reason being is that will then ventilate the key issues, the generic issues. And from experience, what I also find really useful is to tag claimants quite early on. So lead case conference with counsel is really important. Before we select the lead cases, what we'll have is a lead case conference with, normally, depending on the size of the case, if it's 100 clients, it would be with leading counsel. And we will ventilate the key issues, go through the witness statements that have been taken, the expert reports, other pleadings that are quite key to the case, and essentially conduct a mini trial with some of these clients and pick what we find, what we think some good cases and some not so good cases where there's issues that need to be ventilated. I would strongly suggest that people should not just put forward their best cases, because the defendant on any case will see through that, and it will just cause you a huge amount of delay. But contemporaneous evidence and evidence of, for example, in an illness case, reporting of illness, reporting to their GP and to the TOR representative, that's something that should be pulled through into selection of lead cases at a very early stage.
Just to go back a bit in terms of the defendant selecting cases, just to explore a bit the knowledge that the defendant will have, because obviously the claimant will know more about the cases having had access to the claimants. But in your experience, by the time you're selecting lead cases, have there been full pleadings? So will the defendant have seen what each individual claimant is alleging and then had some disclosure so they can make a decision based on what they think their lead case choices should be?
Absolutely. So the case will have been pleaded by both sides, and it will generally come after or around the first CCMC or CMC. And selection of lead cases will come at that point because it will need to come before witness statements are served by each side, because you don't want to be taking witness statements for 100 clients. That would be an absolute nightmare. But it will come after the case has been pleaded, but also when disclosure has been exchanged between the parties. So a defendant, for example, will have things like reporting of illness, parameter reports. The claimant will have served as part of their disclosure exercise letters of complaint, photographs, videos, what have you. So at that point, the key issues will start to unravel, and those key issues usually will be the avenue to how the lead cases are selected.
The reason I ask is because sometimes the timing is a bit different, because in at least one of the group claims that I've been involved in, the selection of lead cases has taken place at an earlier stage because we haven't actually got into formal litigation at an early stage, because the choice has been made to issue protectively to preserve the limitation period and then to stay the claim and have an outside of court settlement process which mirrors the directions you would have in court, including disclosure and witness statements and expert reports, but to do it outside of the court process. The thinking being that it gives the parties more control over things like deadlines, which if the court process is up and running, the parties don't have control of. But the downside of that is that when you're selecting your lead cases, you don't have, both sides don't have as much information as they do in the kind of chronology that you're describing there. I mean, in fact, in that case, that's worked to the claimant's advantage, because it means that the claimants have been able to effectively select their own lead cases without very much input from the defendant. But for reasons you've given, that's not likely to be the case in all cases.
I was just going to say, well, I can't imagine that your case is a package travel case, because I'd love to meet a collaborative approach, a defendant that deploys a collaborative approach, because we just wouldn't get agreement on that type of issue in a package travel case.
So in terms of the case management by the court, effectively, if you're not doing representative claims, then the two options generally are to have a formal group litigation order, or simply consolidate the claims and manage them together. I have to say, in my experience, the latter of those is much more common than the former. I can't think of that many cases that I've been involved in that have had a formal GLO in place. Is that true for you, or is that not true?
Yeah, it's quite uncommon. I've had a couple, or my firm has had a couple, but the problem with the GLOs, it can be strewn with delays. You sometimes lose control of the group litigation. And from my perspective, I think consolidation and case management together can be faster. But sometimes those types of arrangements can be delayed also because of co-counsel. If you're working with a number of different law firms, they might not have, their case may not be as advanced as yours. So you're they're playing catch up. That can cause a bit of delay, but also, again, you can lose a bit of control even if you do consolidate to manage together, because actually sometimes you need to wait and see how the other cases are progressing before you case manage them together or make an application to consolidate.
So one of the other aspects of case management in terms of the court case managing, rather than the claimant firms managing the clients, is essentially what to try. And generally speaking, if there's a preliminary liability issue, then it makes sense, given if you've got a huge amount of claimants, given the cost and effort and time of pulling together all the evidence to value those claims, it makes much more sense, obviously, to have a preliminary trial on the generic liability issue, because if the claimants lose, then you don't have to go through all the process of valuing the claims. one of the main questions, though, in terms of what you try, is whether it is purely the generic issue itself, or whether it is a full trial of the lead cases, which would involve trying the generic issue for those lead claimants, and that judgment would then become binding on all the other claimants, but you would go on to value those lead cases in the trial as well as simply do the generic issue. And the alternative is you simply have a preliminary trial on the point of the generic issue. I think the thinking generally is, particularly from the claimant side, that it's very often better to have lead cases involved, because if you hive off, obviously it depends on what the issue is, but if you hive off the issue from the specifics of any particular case, it can be quite difficult to grapple with it in the abstract. Plus, from the claimant's point of view, you lose the personal human sympathy of having a claimant there in front of the court who can speak about their experience and ground it in a particular human way, which perhaps you lose a bit if you're doing it just on the theoretical generic issue. Although I guess the counter argument is that it will be more involved and complex and expensive to get the evidence together for a number of lead cases. You mentioned having 10 lead cases earlier. It obviously depends how many lead cases you have, but getting all of the expert evidence to quantify 10 lead cases and have them tried as well as the generic issue will make the trial a lot longer and more expensive than it would if you're just doing it as a preliminary issue, a bit like a preliminary trial on limitation.
Absolutely. I think it's, as you say, it's case specific. So it depends on what the issues are and how they've come out in pleading. So, for example, on the case of Aldridge and Toohey, which was a case that Elliot Wolfe of Outer Temple did quite a few years ago, the sticking point that arose on that case was liability in cryptosporidium cases and the failure to warn argument. So that 10-day trial was framed around that key issue. So it was a split liability trial. So the issue of liability was dealt with first because it was the first failure to warn case in an illness outbreak case. And once that was dealt with, then the issue of quantification came up. So it really does depend on the nature of the case. What we're finding a lot more now is that cases are, especially in an illness sphere, they're proceeding on the full work. So quantum and liability together. As far as a claimant's concerned, we think that's better because it avoids delay and the level of pressure for a defendant to cave in is better if the whole thing's connected in one trial.
Yeah, I'm slightly conscious of the time, so I'm going to press on. We've been talking about case management by the court, but the other side of case management is managing the claim as it goes on, including with clients. You talked about initial vetting, but how does that process work through the life of the case?
Having a good spreadsheet. Spreadsheet's really important, as basic as that sounds, but it's something that I really struggled with because I'm not the best with Excel, but that is something that's really important. But what I find is really helpful just to make use of what you do very early on in the case is tagging claimants. So as you're taking instructions, what I do is I encourage those that are working on the case is to tag cases which are either not so good or you have concerns but can still get home on liability, but also tagging those cases that are going to be good from a lead case selection perspective. So early on, just what we always do is to keep an eye on lead case selection and have that in mind, but also good instructions to experts, tailoring your instructions to ensure that you're not just sending a pro forma, but also you're looking at what the main issues in play are and tailoring your letter of instruction to your expert to have that in mind. But also what I found on the larger group actions, if you've got a particularly high quantum case within the group action, meeting clients face to face is gold dust. It's really important. It's not always the way with large scale group actions because you just wouldn't be able, and it wouldn't be proportionate to meet every single one of your clients face to face. But I guess that's the benefit of having a more virtual world now. But historically, we would make an arrangement to meet just a select number of clients, and those normally would be your lead cases. So that's something that I would say is quite useful quite early on to keep an eye on which cases you would want to take forward as a lead case.
Because we are slightly low on time, shall we skip on and talk about, see if we got time to talk about two more topics. One is settlement and ADR, and then costs. Obviously, there are a number of ways to skin a cat, particularly in group actions, because they will all vary and depends on the nature of the claim and the nature of the claimant cohort. But the first thing to think about is the process for settlement. And one option is to have some sort of a formal settlement process, either outside of or parallel to the court process, to resolve the whole claim. And I mentioned earlier that one of the ones that I'm involved in at the moment has had that going on. And the benefit of that is that if you take it, obviously you have to issue the claim in order to protect the limitation position. But if you take it out of the court process, the parties have between them, you do have to operate collaboratively, but the parties between them have much more control over the timetable of what happens when, and can try and work together to resolve things. But as you say, that requires the ability to work collaboratively, and you can set that up so that you don't have to duplicate work. So effectively, you're doing everything that you would be doing in the court process in parallel, but it just means that when you get to the stage of joint statements of experts, you don't have a trial breathing down your neck, and there's a bit more room for maneuver and for discussion. And then the benefit of that is that if you are able to sort of break the logjam, very often it will be agreeing some sort of agreement on the generic issue that will then enable you to move on to look at the individual cases. You can then do that still within your own control and within your own timetable.
Yeah, absolutely. Well, something that we've found works really well in this respect is agreeing a protocol with the defendant. So agreeing the type of areas that quite early on, to some people call it a way forward meeting with the defendant, agreeing a scheme of damages, for example, or a case management protocol quite early on in the proceedings, or even before proceedings. And that's something that we found has worked quite well to get cases over the line and get them concluded. But again, it goes back to how collaborative your opponent is, and that's not something that's always possible with working with certain defendants, but it certainly has worked with others.
And the second point there is that it doesn't have to be one size fits all. So if either because of a lack of collaboration or because there's a genuine difference of opinion about how likely the claimants are to succeed on liability, it may be the case that you have to have a trial with your lead claimants to resolve liability. But then if you've got 500 claimants left, you don't want to have to litigate all of those. You can take the findings of the liability trial and then institute the kind of process that you've been talking about in order to resolve the individual claims. So that's the first side of settlement. That's about process. In terms of the broad process. The second part of it is the actual settlement of individual cases. And obviously, one of the ways in which group claims work differently is that it's much harder to take instructions from 500 individuals about settlement and go back and forth about offers and counter offers than it is when you've got a small number of claims. So on a practical level and on a slightly more granular level, how do you deal with that in your larger group claims?
So what we do quite early on is value a case, especially where prognosis is a lot more clear. So if prognosis is definitive, we will go to a claimant and provide settlement parameters, and we'll get parameters to settle the case quite early. So we don't need to keep coming back as long as we're negotiating within those parameters. But ultimately, the final sign-off of the agreement, we do need to go through that long-winded process of spending the time explaining the settlement, explaining the consequences, for example, of a Part 36 offer. And yes, that's long-winded, but it has to be done, and we've got to obviously comply with our regulatory obligations. The only other thing, Will, that I would say in terms of global offers, yes, sometimes they're the only way that you can break a logjam with your opponent, but something that I really don't like, because it puts you in a, as you all know, as PI practitioners, it will put you in a conflict position with your client. So on the right cases, they can be used, but I would steer clear of that type of settlement.
Sure. We're coming near the end of our time. We're just going to touch very briefly on costs, because that is obviously a very important part of the process and a much more complex one for claimants running these types of claims. So do you want to say a little bit about the things we've touched on the slide there?
Absolutely. I know cost budgeting has not been something that all claimant practitioners have liked, and it's been something that's been embedded in since 2013. But as far as I'm concerned, I think it's quite helpful. It gives you a more realistic and definitive position in terms of your costs, so that I know clients like it because they know quite early on what their costs are going to be. And I definitely know ATE insurers like it too, because it gives you a bit of, certainty around it. But as far as I'm concerned, cost budgeting is good for group actions, but housekeeping and keeping a tidy file for this type of thing is really important. Another thing that I found really useful for group actions is preparing a work done document for your first CCMC, presenting that to your judge to let them know the type of work that you've carried out already and what you intend to do moving forward. A lot of group actions, as I've just explained, are very front loaded because it requires you to do your homework and requires you to invest heavily at the start. So that work done document is key. And then in terms of billing, the only other thing that I just wanted to say before we wrap up, obviously with billing, it's really important that you get across quite early and get into your directions, your case management order, that there's joint and several liability for all of the claimants. That is something that is must, if possible, go into your directions order, because otherwise a defendant could go after one lead client, for example, lead claimants, for example, for the entire generic cost proportion, which would just be horrific. So that's something that I wanted to get across. And also the sample bill and why the generic file is so important. Again, I go back to housekeeping, but due to the joint and several liability aspect of a group action, it's important that your generic file is clear and it can be costed and billed easily. So all I wanted to say with that is about that was try to agree a sample bill with the defendant quite early on, so that there's less arguments at the back end of your case.
I think that's probably the end of our time. I don't know if we have time for any questions, but if we don't, please do come and find us on one of the breaks.
Executive position that we're going to extend your time.
Right.
It's actually plain to me, we could spend a whole afternoon talking about group actions. And having spent more than 3 years seeking to resolve the civil claims arising out of Grenfell Tower for 900 claimants, I've learned how many other issues there are. Just wanted to ask you both a couple of questions, really, about collaboration and ADR. If you have any substantial group action, particularly if you've got multiple defendants, everyone's got to collaborate if they're going to make it work at all, haven't they? Otherwise, the defendants are never going to know where they are, and it's just going to get more expensive. Jatinder, is that your experience?
I agree, but in practice, it doesn't happen. I think it's starting to happen a lot more now. I think, unfortunately, about 5 years ago, for example, in the illness sphere, a number of claimant law firms entered and muddied the waters in terms of, some claimants that were dishonest. And so that has created a mentality amongst tour operators to defend everything, to be as uncollaborative as possible. But fortunately, we're coming through the other end of that, and things are starting to become a bit more collaborative. There's a lot more agreement that's now reached. A lot more cases are actually settling before they even reach the court.
Well, that's what I was just going to trip onto. Well, I mean, if you're going to get involved in this litigation, ultimately, however much defendants have to be dragged kicking and screaming, and sometimes they do, you have to get into ADR.
Yeah, and I think that in my experience, although there may come a point where either side's view of the merits of the case or the value of the case, are irreconcilable, and you can't get to a point where you can settle them. Up to that point, it's in everyone's interest to collaborate, because you need to find out where the actual sticking point is, and it doesn't make much sense to be not collaborating when it's not getting you any closer to finding out what the sticking point is.
And just in many of the skills of this, they're legal skills, of course, but you've emphasized that part of it is managing the claimant cohort, isn't it? And managing the issues that may be disparate and having to adopt a spreadsheet mentality.
Absolutely. I think a lot of it is technical expertise, I understand, but some of it is quite straightforward, just management of people, management of sometimes very difficult people. But yeah, it's a bit of both.
And time for one or two questions from the floor if you want. Again, we may abbreviate the tea break a little bit, but you'll still get tea. Any questions from the floor?
If anyone thinks of any later, do please accost us when we're having a cup of tea and ask them.
And we'll do a bigger session on group actions next time. Well, thank you, Jatinder. That was really well done. I may say so. I love the dialogue between you. I thought it was very much better than just lecturing it as well. Thank you.
Thank you. Thanks.